Thank you all for coming out. We want to thank our speakers for coming. We're really glad to have them here for this debate. Just to introduce them quickly, Professor Epstein is the James Parker Hall Distinguished Service Professor Emeritus at the Law School and Senior Lecturer at the University of Chicago Law School. And Professor Koppelman is the John Paul Stevens Professor of Law and Professor of Political Science at Northwestern University. And just so everybody knows kind of the format for today, Professor Epstein is going to start with 15 minutes, and then Professor Koppelman will go for 20 minutes, and then a rebuttal by Professor Epstein for 5 minutes, and then we'll open it up for questions. So please join me in thanking our speakers.
Thank you so much for inviting me here. It's a very complicated and difficult topic. So what I'm going to first do is set out what I think to be a kind of prudent and moderate position, trying to explain why it is that there are serious constitutional difficulties with respect to the individual mandate portion of the case. Well, let's start off by trying to indicate how it is that the mandate came to pass. There is a very ambitious program for universal health care coverage to be run largely through private markets. And in the design of this particular program, what the government tried to do was to achieve many goals simultaneously. The first goal was to make sure that nobody would be able to free ride on the system. And the theory was that if you had to pay some kind of an individual mandate, that would in effect be an incentive for you to join up into the system so that you would not take from it more than you contributed to it. At the opposite end of the spectrum, there was a desire to have extensive cross-subsidization within this system, such that in order to make sure that the rates for those individuals who are in poor health or who are somewhat older could be brought down to manageable levels, what you did is you increased the rates that would be charged to those people who are younger and healthier, so that the premiums that were obtained from the bottom end and the age distribution would subsidize those people at the other end. And the third feature that they engaged in this particular program was one which essentially said that you could join and withdraw any health care program at whim. There were no waiting periods before you could enter, and there was no requirement that once you joined that you had to stay after your particular provisions were or conditions were cured. So there's a huge problem here associated with moral hazard, whereby people will come into the system, try to get very large payments and then leave, and it was thought that the individual mandate would be some kind of a device which could stop that kind of movement in and out of the system. For those people who think about this not as a constitutional issue, but rather think about it as an economic issue, there is at least a very respectable case that the system cannot work because the size of the mandate is not going to be large enough to stop the moral hazard problem or to control the kinds of subsidies and to create the kinds of subsidies that you need in order to make this particular program go forward. And so in one sense, if you start to look at this particular program, you can say, well, the mandate is an essential part of a comprehensive national scheme to try to impose health care for the benefit of all. And so therefore, in fact, it should be regarded as constitutional under the Commerce Clause. And in fact, when I started to think about this case many years ago, my view was that this argument was probably going to be able to win, and I was somewhat surprised to see the way in which the opposition to it developed, and it developed along two fronts. The first was an effort to try to explain why it is that the mandate was sufficiently novel that even though it had a certain kind of backwards economic logic to support it, nonetheless it was unprecedented in our jurisprudence. And the second argument was to try to go back to the foundations of the Commerce Clause to see whether or not, when we understood how the system was originally designed at the federal level, or whether in fact this particular mandate was something which could happen under the originalist versions of the Constitution. So let me take both of these points up together. The great expansion in the American Constitution was, of course, in the two watershed decisions of Jones and Laughlin in 1937 and Wickett-Filbert versus Filbert in 1942. And what the government was able to persuade the court was that any kind of activity that you engaged in the private sector, which either increased the volume of goods that went through interstate commerce or reduced it, or in the alternative, raised the price or reduced the price of goods in interstate commerce, so affected interstate commerce that it should be regarded as something subject to the regulation of the federal government. And there is no question that this is a very radical shift from the earlier views associated with the scope of the Commerce Clause. The great achievement, if it's that, of my friend Randy Barnett was essentially to say that notwithstanding the fact that there was huge and comprehensive forms of regulation under the Commerce Clause, that the critical requirement that there be some activity that either increases or reduces the flow of goods through interstate commerce was not satisfied in this particular case. It is commonly said, and I think Andy Koppelman surely agrees with that, that there is comprehensive federal power to regulate the insurance industry. And the argument that comes back from the other side is that you're not regulating the insurance industry in this particular case. What you're doing is you're regulating those kinds of individuals who have no desire whatsoever to participate in any kind of a social scheme of insurance and essentially commandeering them into serving the particular obligations associated with running a larger federal government. In my own view of the world, I think this is much more powerfully an autonomy claim than it is a Commerce Clause claim, but given the backwards and upside down jurisprudence associated with the Supreme Court, which I think is the norm on virtually all major substantive issues, the autonomy claim has gotten virtually nowhere in any of the courts. It is, I might also add, an argument that could be raised with equal force as against the states, whereas the Commerce Clause argument is only directed against the federal government, not directed against the states at all. And so the question then is can we in effect treat this as an important kind of limitation on what it is that the federal government can do? And I have no doubt that it is a perfectly coherent line if somebody wishes to defend that particular line, in the sense that I can look at every previous scheme of government regulation, however wise and mischievous, and always find the kinds of activities that were associated with its operation. So if you wish to go back to Jones and Laughlin, what happens is if you wish to enter into business in order to hire employees, you must now conform to the requirements of the National Labor Relations Act insofar as they relate to collective bargaining. And if you look at Wickett and Filburn, it says nobody's under a duty to become a farmer, but if in fact you become a farmer and you wish to raise your grains, you're going to be subject to the output limitations that are imposed upon you through the elaborate set of elections and administrative procedures that are introduced under the Agricultural Adjustment Act. In this particular case, we're not regulating any firm of any sort or any kind. You're trying to bring people into a program. You're trying to bring people into a program where you've announced in advance that they're going to be systematic losers, because even though part of the consideration that they are going to have to pay will cover for their own health care expenses, at least some other portion of their health care expense or their payments are going to take care, by definition and by design, the health care expenses of others. And so there is, I think, not an easy answer to the question that Justice Kennedy posed at the outset of the argument, which put everybody's predictions into turmoil, which he said, is somebody under a duty to enter into commerce so that the government is now in a position to regulate it? And I do not think that it is an unreasonable answer to that particular question to say no. Is that you've got enough control of the federal government over all sorts of things that are going on by regulating those people who choose to go into commercial activity. There is no particular reason to do this otherwise. Now, one possible way to escape this particular conclusion is to say this is just a mere sort of typing error. If we want to attach this to an activity, we can. And so we can say that if anybody wants to drive a car in the United States or to acquire a job in the United States, they have to agree to pay the individual mandate. And I think, in effect, these efforts to try and link the mandate to some other kind of activity suffers from two kinds of problems. One of them is it was not done in this particular case. And so what you're trying to do is to uphold the statute by basically trying to rewrite it, which in general is a mistake. And secondly, if you did try to rewrite it in this fashion, I think it would be, by and large, ineffective. There is a large doctrine of the unconstitutional conditions, which says that you just cannot attach any condition you want to any kind of activity and hope that it's a day. So that it's one thing, for example, to say that you're allowed to drive a car on the public roads only if you get yourself a license which ensures that you're a safe driver, or get insurance so that you could cover these accidents. But it would be something else to say that you could only drive on these particular roads if you were prepared to surrender all sorts of other rights that you had unrelated to the driving in question. And so this effort to try to find the activity, whether it be driving on highways, taking jobs, breathing out carbon dioxide, or whatever else it is that people do on a sunny day, I think in effect that these arguments are going to fail. Now the question then is, do we want to accept this? And this is a Supreme Court case, and if it were a knockdown argument, it seems to me that everybody would have recognized it long ago. And so I think what you have to do is to evaluate the argument in a different kind of context, which is to think very hard about the question of whether or not you want to extend Wickard and Filbert in this particular direction. There's absolutely nothing that I can say which indicates that that extension would be wildly improbable, but I think I can do something to make you cautious about it by pointing out that Wickard and Filbert itself is essentially one of the worst reasoned constitutional history decisions in the history of Western civilization. Just to put a nice term on it. And it's interesting, after Justice Kennedy's question, the way in which the debate has gone has been an effort to do a much more originalist defense of what has happened. So we have references to navigation acts and to acts having to do with the militia passed in the 1790s, which are thought to somehow or other justify the proposition that it's okay for the government to impose general obligations upon you. Both of these activities, I think, are arguments fail. With respect to the navigation acts, it turns out that the only way the conditions can be imposed upon you is if you wish to enter the United States through navigation, if you're in a foreign ship. And to have conditions attached would say that if you come here, you can't dump your sailors on our particular facilities and hospitals without paying for the change, is a perfectly sensible kind of condition that meets the relatively narrow tests for constitutional conditions that I've talked about earlier on. And when it comes to anything associated with the militia, I think the point that one wants to make in general in looking at that is that the militia clause clearly states that the federal government has the power to set the discipline by which the states will train their militias, and it seems to me under that power, the distinction between the affirmative duties and the affirmative actions and the inactivity are really quite beside the point. What is most instructive is that if you want to go to the earlier history, you have to look to Wickard and Filbert. Not Wickard and Filbert, Gibbons and Ogden, excuse me. And this case takes such a narrow view of what commerce is that you couldn't get within a light year of the current plans if you treated it as a faithful exposition of the original constitutional design. In that particular case, Justice Marshall said that I'm giving you a very broad and extensive reading of the Commerce Clause. And what that means is it covers navigation from the point of origin to the point of conclusion of any particular journey, but it doesn't cover at any point the inspections that might take place either before or after the journey began. And indeed, every single constitutional law case dealing with the Commerce Clause prior to Jones and Laughlin basically essentially had this conception of a journey. They realized that there were no geographical divisions between federal and state jurisdiction, so that what happened is things that preceded a journey were within the exclusive control of the states, things that followed the journey were within the exclusive controls of the states, and the only thing that you could regulate was the stuff in the middle. In fact, that had to be the view at the time, because the basic structure of the federal power under the Commerce Clause was shaped by the reality of slavery. And any broader reading which would have allowed the Congress to abolish slave institutions would not have passed muster at the time of the first Constitution. Please do not read this as a defense of slavery. Never seen a good libertarian defense of slavery, and I'm not going to try to offer one here. But I think what it does do is it tells you something about the structure and the way the arguments go. To give you but one more illustration of how this thing played out in the period prior to the time of Jones and Laughlin, it's instructive if you look at the Pure Food and Drug Act of 1906, is it does not allow the Congress to regulate the manufacture of drugs in the state, but it does allow them to regulate the manufacture of drugs in the territories. And the reason that this distinction was made is that everybody understood that both Gibbons and Ogden on the one hand and E.C. Knight, on the other hand, precluded the efforts to regulate manufacture or indeed the provision of health care. So the view that I would take is that the overall expansion beyond the Gibbons and Ogden situation is by and large a complete constitutional mistake. I think it's in fact indefensible on substantive grounds because in both the labor cases and the agricultural cases, the only real purpose for the expansion of the commerce power is to create powerful monopoly and cartel institutions in both these industries. So now when you ask the question, should we or should we not extend Wickett and Filbert and Jones and Laughlin one step further, I think the prudent response is we've gone far enough down this road. The decisions which in fact overruled the earlier cases are much less respectable than anything that's being argued at this particular point, that we have to take some look at the desirability of previous decisions, given the fact that these things are, I think, wildly counterproductive. We don't want to double down on a mistake. There is a principled ground of distinction which may not be compelling, but when it's set against the background of a constitutional history which has seen all too great an expansion of federal power, the appropriate thing to do is to deny the mandate and to let the federal government figure out some other way in which it wants to run these programs. As Randy Barnett has often stressed, and I will end on this note, if you strike down this particular statute, there's not a single other statute on the federal books that gets struck down, so that you have a way of imposing a principled limitation, which at the same time is a surgical strike. This is not perfection, but I think it's a lot better than what the alternative is of allowing the program to go forward to a very uncertain fate. Thank you.
Okay, well, this is actually not the first time that I've debated healthcare with Richard, so I figured out this time that we were going to start by talking about healthcare reform, and we ended up by proposing the end of Western civilization as we know it. So I try to address both of those things, and really just go back to the original question of what the Constitution is for, because I think that I take it that the basic claim here is, boy, it would be really good if we could dismantle the entire New Deal apparatus, if we could empty out many of the large buildings in Washington, D.C. and sell them off to the private sector. That would be a better world. But since we can't do that, let us at least have this new constitutional limitation, which nobody ever heard of before, the action-inaction distinction. But if we impose that, that at least shows that there is some limitation. And so it's important to make the symbolic point that there is some limitation. It does also stick a pin in the most important progressive legislation of the last several decades, and so prevents the federal government from addressing one of the most pressing problems the country is facing. But never mind, it's more important to draw this symbolic limitation on the New Deal. So let's start by saying, what's the Constitution fundamentally about? And Richard, toward the end of the talk, went into originalist mode. So I guess so that's fine. I'm happy to talk on that ground. I mean, there is a problem when you look at any text and you try to figure out, so how do you faithfully interpret a text? How do you faithfully interpret its original meaning? And it certainly is the case that the framers of the Constitution would have been surprised by all those big buildings in Washington. Never would have imagined an environmental protection agency or a food and drug administration. You just wouldn't have imagined anything like that. And so doesn't that mean that Richard is right, that if we're going to be faithful to the framers, we ought not to have these institutions? Well, it's always a question of at what level of abstraction you understand intentions. So suppose that you're a theater director performing Shakespeare's Romeo and Juliet, and you want to present a faithful interpretation of the play, faithful to Shakespeare's intentions. So here's a puzzle. When you are casting the role of Juliet, is it permissible for you, if you want to be faithful to Shakespeare, to cast a performer who's female? There were no female actors on the Elizabethan stage. Juliet was originally played by a teenage boy. So aren't you fundamentally betraying Shakespeare if you cast Claire Danes as Juliet? Well, I think that you have to figure out, there's multiple intentions here. The fundamental intention that Shakespeare had was he wanted the audience to be moved to tears. And any particular bits about staging this or casting that are subservient to that larger purpose. So what's a fundamental purpose of the Constitution? Well, what was wrong with the Articles of Confederation? What was wrong with the Articles of Confederation were that there were large pressing problems that the country was facing that nobody could solve. Not the states and not the fairly weak Congress. Congress couldn't levy taxes. It had to request funds from the states. Federal didn't always come, so federal finances were dire. That meant a weak military in a country surrounded by foreign enemies. This wasn't good. So the fundamental purpose of the Constitution is to make sure that since I know that this is a red flag for Richard, I can't resist quoting Robert Stern, who first offered 1944 article. The fundamental intention is that no hiatus between the powers of the state and federal governments to control commerce was intended to exist, and the people of the United States should not be entirely unable to help themselves through any existing social or governmental agency. Now, I think that means that when you read the powers in Article 1, Section 8, you should read them through that lens. Is it the case that there are problems that the states are separately unable to solve? We actually know that this is what was intended in the Constitutional Convention. In the Constitutional Convention, there was a resolution to empower Congress to legislate in all cases where the states were separately incompetent. And then that went off to the Committee of Detail, which came back with Article 1, Section 8, which was then adopted without discussion. So they thought that it was the same thing. All right, so with that in mind, now I guess one area of overlap between me and Richard is that I'm not bowled over by the logic of Wickard versus Filburn either. It seems to be that absolutely everything, together with other things similarly situated, affects interstate commerce. There are some activities where you just can't plausibly say Congress is regulating something that the states can't separately regulate. So United States versus Lopez, for example. There's no reason to think that the states aren't as capable as the federal government of handling handguns near schools. There's just no reason to think that the states aren't able to do that, so there's no particular need for the federal government to get involved. I would have liked Wickard to talk about that. The problem with Wickard is that it's not Robert Sternish enough. All right, so what's the problem? Why, if they passed this, the Affordable Care Act, it's 2,000 pages long, it's complicated, hard to keep track of it all. Why did they do that? Why didn't they just leave the system alone? Well, the fundamental problem is that the cost of health care was steadily rising in the United States, and as a consequence, the system was already unraveling. More and more people were losing their health insurance. So, since 1980, in the bottom fifth of American earners, there were 18% without insurance in 1980, almost 40% by the time that the bill was passed. It's actually easier at the top of the income distribution, but the upshot was the number of uninsured people was steadily rising, and this is bad. If you are uninsured, you are likely to suffer avoidable illness. You get less preventive care. You're diagnosed at a more advanced disease stage. Once you're diagnosed, you get less preventive care. Women without insurance are nearly 50% more likely to die of breast cancer because the tumors aren't diagnosed at an early stage. They don't go to the doctor as often. We don't know how many people lack of health insurance kills. Estimates range pretty wildly, between 22,000 and 45,000. So it's a pretty broad range, but that's still a lot of people, and the ones who don't die are often financially ruined by medical expenses. So why would you, now all of those are just facts. They don't indicate that you ought to intervene. And I think there's a fundamental divide about whether you ought to intervene. So Anthony Kennedy, he said, there's a problem, governments has a duty, the government is saying that it can tell the individual citizen that it must act. And generally, at common law, Kennedy said there's no duty to rescue. So why should individuals be required to pay money into the system, as Richard said, to benefit other people? Well, it depends on what kind of thing healthcare is. Do you think that it's a right, or do you think that it's an ordinary commodity? If it's an ordinary commodity, then it's fair to make everybody pay for their own coverage. Insurers should make their customers pay premiums in line with the risks that they represent. So if you're too poor to buy insurance, that's tough. You can't get things in a market without paying for them. And if you've been sick in the past, that's tough too. Your insurance is going to be ruinously expensive, and it's going to exclude the disease that you've had in the past that you're most worried about. Markets are normally good for consumers. Providers compete to provide high-quality products, but insurance markets are different. The way that an insurer profits is by taking in a lot of premiums and paying out as little as possible in claims, and that means there's an incentive to restrict your policy to people who are young and healthy. The least expensive 50% of health consumers account for about 3% of the costs, and the most expensive 10% account for 70% of the costs. So there are competitive pressures on insurers to protect themselves from large payouts by getting rid of the sick people, raising their rates, canceling their policies, not insuring them in the first place. If you do that, you'll financially outperform your competitors. So they're behaving rationally in a way that a well-functioning market's going to reward. The other claim is that people ought to have a right to basic health care provision. Such a right, it's not a fantasy, it exists in every rich country except the United States. But that means that there's got to be cross-subsidization. The money has to come from somewhere. So why think that the states can't deal with this separately? Well, if a state provides, suppose, all the way to single payer, you come here and we'll take care of all of your basic health needs, it's a powerful incentive for sick people to move to that state. I mean, it really is the case. Your life depends on it. You need a heart transplant and you can't pay for it. You go someplace where people are going to pay for it. And that means that it is tougher to be younger in that state. It's easier if the state is already rich. It's not a coincidence that the only state that was able to enact a health care bill was the Massachusetts, which has an unusually rich tax base and an unusually low number of uninsured to start with. I think there's a fundamental puzzle in the claim that's been made for unconstitutionality. The claim that this is unprecedented, actually, this is somewhat klutzy and roundabout version of what the government already does with Social Security and Medicare, two programs that would clearly be unconstitutional if we went back to the old pre-New Deal regime. So if government is allowed to tax you, and if government is allowed to buy insurance for you with the money, and if government is allowed to then give you the insurance, if it can do all three of those things, then the question of how it goes about doing it, it's not clear why any large constitutional issue turns on that. This is not just about the Commerce Clause, this is also about the Necessary and Proper Clause. Everybody in the class, everybody here has read McCulloch versus Maryland? Congress gets a choice of means, and the choice of means doesn't have to be an aspect of the very thing that it's regulated. So one example in Marshall's opinion in McCulloch versus Maryland, he says, Congress has a right to operate post offices. That means that Congress has a right to make it a crime to rob the mails. If Congress has a right to make it a crime to rob the mails, Congress has the right to have federal prisons. If it's got a right to have federal prisons, then it has a right to try to catch people who escape from federal prisons. Now, you'd say, there's something weird about this. You've got federal marshals going through the swamp with shotguns looking for a guy, and you ask, what are you doing? Oh, we're operating the post office. But if you disagree with that, then you disagree with McCulloch versus Maryland. Once you say that Congress has got a right to regulate the insurance industry, And if Congress can address the problem of pre-existing conditions, which is a massive problem, you guys, you all look pretty young and healthy to me, but I got news for you. Some of you are going to get sick, and I very much hope that most of you are going to get old.
Prematurely?
There is only one way to avoid getting old, and that's to die young. So when you say that if we have a system of health care provided to everybody, that's you subsidizing somebody else, well, it's also subsidizing you by and by. Now, some of you are going to lose in this lottery. Some of you are going to be in robust health when you get past retirement age, and you're rarely going to go to the doctor, and you'll have paid in all of this money for nothing. Well, I've been paying life insurance for years. A lot of good it's done me. Here I am. I'm still alive. But I still don't regard that as money wasted. There's a last issue. There's just a fairness issue here. Richard said that some of the people challenging these laws have no desire to participate in any scheme of social insurance. And a number of the plaintiffs in these challenges to the health care mandate said with an absolutely straight face, I don't plan on ever availing myself of any health insurance, of any health care that I don't pay for out of my own pocket. Now, it seems to me that Congress is not obligated to be an idiot. Congress is entitled to say, we don't believe you. We think that if you get cancer, you're going to sing a different tune. And then you're very much going to want care for your cancer. And then you're going to suddenly want health insurance. And given that that's the case, we can reasonably burden you now for what you're likely eventually to avail yourself of. Now, there is a last response, actually came out at the oral argument in the healthcare case, because the Solicitor General argued that it's legitimate to require people to purchase insurance because the country's obligated to pay for the uninsured when they get sick. And Justice Scalia said, well, don't obligate yourself to that. So, I mean, that's the other alternative. If you could really say to these folks that, well, if you don't have insurance, you're out of luck. We are not going to expend any resources for you. In fact, I take it that Scalia doesn't think that there's really any obligation at all to care for sick people who can't afford to pay for medical care. The obligation, it's not really an obligation, it's discretionary. You could choose to obligate yourself or not. In fact, Scalia's sentence was phrased in the imperative. Don't obligate yourself to that. This goes to the question of whether there's some fundamental right to make one's own medical decisions, something that turned up in one of the lower district court opinions, that there's a right to make one's own health decisions free from government interference. Well, some people have said that the claim against the health care mandate is Lochner all over again. But notice the claim that you've got a fundamental right to make your own health decisions was rejected by the Supreme Court the same year that it decided Lochner in Jacobson versus Massachusetts, which was a challenge to a statute that required people to get vaccinations against smallpox. So even the Lochner court wasn't willing to go quite this far. Maybe I'll stop there, and you can go to questions.
No, thank you. Let me see if I can make just a couple of points. One is a lot of what we're talking about here depends upon the level of abstraction to which we are prepared to go. And so what Andy said, and said rightly, is that when they designed the Constitution, they wanted the federal government to be able to handle those problems that the states were not prepared to handle or competent to handle in their own rights. And what happens in this particular situation is they did exactly what they thought they needed to do. What they thought they needed to do is to have a taxing power, so they had a taxing power. They thought that what you needed to do is to find a way to open up this nation to basically interstate commerce, so they gave the power to Congress to regulate commerce but not manufacture. because their vision was they wanted to have an economic free trade zone in the United States. It was not an argument that they wanted to have comprehensive regulation of all gainful activities that took place within the state. They also had all sorts of ways under the Republican clause of government in which the federal government could intervene upon the application of the governor of the state in order to quell insurrection and violence. They created a militia, and the purpose of that was to both allow it to be brought into federal service to defend the nation and to be used by the states on their own accord when they had some local issue that they had to deal with. There is not the slightest bit of hint at any time or place that they thought that one of the basic problems that a nation was not able to handle was the ability to maintain cartels without federal government. Essentially what happened in both of these cases is that the competition between the states made it impossible to maintain a system of minimum price controls for agriculture or to work any effective system of unionization. I do not think that there is any kind of social welfare that can be attached to the creation of monopoly-type and cartel-type institutions. I don't think there's the slightest shred of evidence that anybody at the founding theory thought that this was what the federal government was supposed to do. The case against monopolies was as well understood then as it is today, and so you cannot just simply say because somebody has a collective action problem, it's one that you want to solve. Every competitive industry has a collective action problem that a cartel can solve. So I don't think that gets you anywhere. What they did is what they wanted to do, and they got it right. And there's still not the slightest shred of evidence what they wanted to do here had anything to do with the maintenance of these kinds of institutions. And make no mistake about it, when you standardize terms as they do with respect to the private exchanges under the Health Care Act, that is a form of cartelization, which will wreck these industries. The second point is there is a national problem, and how did it come about? And here's the following little puzzle to ask yourself. Under Andy's account, which is correct, that the number of people who got employment insurance through their jobs in 1980 was about 60%. It's now down to 50%. The number of people who essentially are uninsured at the bottom tier is higher today than it was then. If this is an inherent feature with respect to the ways in which state and national governments run, then in effect you have to find some explanation as to why the consistent decline in this thing. And there is an explanation for it. And it has to do with many things, one of which is the absolute willingness of states to impose mandates upon employers which require them to buy insurance which their customers don't value. And so what happens is when their employees don't want it, the policies become too expensive, and they drop the entire system. So you manage to lose 10% of the employment force out of this. That roughly works out to 15 million people and their families. You've got a royal problem. What do we need to cure this thing? But basically you have to do is to say that forced provisions of that sort at the state level are not consistent with the police power, and therefore what you have to do is to strike them down. And at that particular point you will open up state markets. What else can you do through the federal government to solve this? There are all sorts of ungodly statutes which prohibit insurance companies from one state from entering into business in another state, so as again to preserve various kinds of monopolization. Federal government wants to do something useful. What it could do is strike down those barriers to entry without doubt within its commerce power. What did they do? In order to get their healthcare system, the first deal they made was with the insurance companies in order to preserve the monopoly institutions which were then in place. If you go through every one of the so-called defects associated with the healthcare system, what you discover is, without exception, each and every one of them that we have is attributable to some kind of state or federal regulation with respect to the way in which these markets work. And so to argue that somehow or other it's market institutions that fail is in effect to miss the massive role that federal and state regulation on all sorts of issues have done in order to wreck the system beyond its recognition. And I didn't talk about EMTALA, which is the Emergency Care Act. It did result in shutting down about 25 to 30% of the emergency rooms in the United States because they couldn't take the force of the mandates. And so what the government should first do, if it wants to solve these problems, is to undo state regulation and to repeal its own, rather than to heap on another set of regulations, which is simply grotesque relative to what has happened. And the third point I want to make has to do with the way in which we think about the spending power. You know, I'm a quaint sort of fellow. You go back and you read the spending power. Essentially, it has nothing whatsoever to do with transfer payments amongst individuals. It has to do with the ability to tax and spend for the common defense and for the general welfare of the United States. What they were worried about was the classic form of public goods for the nation that no particular state could survive for. And a transfer payment between individuals either within or across states has nothing to do with the original design, which lasted for a while, but of course has been completely gone in recent years. But even if it's gone, this is what one would want to say, is there is absolutely no reason why it is either necessary or proper to impose this particular mandate. The appropriate political constraint is, if you wish to fund those people who are in need, do so out of general revenues. At that particular point, under the current Commerce Clause and Spending Clause jurisprudence, there's no difficulty. But there is this very big difference. The moment you do it in this particular fashion, we make some people pay for other people, the danger of factional politics increases mightily, because we now know who's fighting whom. And we can get a fractional difference that you cannot get when you put things out in general revenue. There is one overriding concern that always bothered the framers, which is how it is that you manage to organize your public institutions to avoid or at least to minimize the risk of faction. So the point would be, if in fact general tax revenues are available to handle this problem, it is not necessary to impose the revenue requirements through the mandate. And if in fact you're going to distort federal and state relationships, it's not proper to do that either. This is not a case like the one having to do with the post office and the apprehension of criminals. In fact, if you go back and you read McCulloch v. Maryland, one of the things that our friend Marshall is very clear about in a decision which took place before Gibbons and Ogden is that it has to be execution for carrying into effect the foregoing powers. When it came to Gibbons and Ogden, you weren't concerned about means, you were concerned with ends, and he explicitly repudiates any reliance as improper under the necessary and proper clause in that particular decision. So if you want to understand what's going on, what happens is we are seeing the shipwreck of progressive institutions. When this thing gets put into place, the last thing you'll worry about is the mandate. What you're going to worry about is, in fact, they're going to put so many constraints on the way in which people can enter into the private pools that you won't get any takers. That will force people off of the rolls into some public program which will not be there. And if we're trying to figure out what consequences are, never ever trust a government program to be faithful to its own objectives. The best prediction that I can make on fairly close study of the way in which this program works is the number of uninsured people will increase in the United States as the system falls apart for one reason after another. So we cannot take a rosy view in which intentions matter much more than consequences. When you royal markets to this extent, when you have these high transactions costs, what you do is you kill voluntary transactions and therefore put ever more pressure on the public system, which in our current state of deficits and general confusion is very ill-equipped to bear it. Thank you. No. You got 3 bottles of water.
They're all for you.
Thank you. Somebody?
Thank you both for coming to talk to us. I was wondering if, with a vision of the Constitution that permits the constitutionality of the Affordable Care Act, would supporting that position make other parts of the Constitution redundant? In that, if you can do this, do you need other things in Section 8 of Article 1? And if so, would that come?
So the claim is that if Congress has the power to regulate, well, I didn't say a lot about the more general reading of what are the boundaries of the commerce power. I actually like Jack Balkin's argument that it's yeah, wow. Yeah, I like Richard, but I can't resist.
It's like throwing acid.
Yeah, I feel so bad. He's so nice, but I can't. So what is commerce among the several states? It's interaction between people that crosses state lines. Now, does that cover absolutely every one of the other enumerated powers? I think the taxing requires us. I think that, well, you're asking for a whole theory of the commerce power in context here. Not sure how to give a short answer to this. I can say something about what Richard wanted to exclude, which is transfer payments between individuals, and the idea that this broad understanding of the commerce power, which let's face it,
tax and spending.
this is what although one thing the pre-New Deal court understood was that if you're going to restrict the commerce power, that's a pretty ineffective thing to do if you're going to let Congress do absolutely anything that it wants with the taxing and spending power. So you got to restrict the taxing and spending power as well. So that's Bailey versus Drexel Furniture and all of that. So that means that you'd have to get rid of programs like, take Social Security, for example, which is a transfer payment between individuals. Well, I guess the question is really, and maybe this is our fundamental disagreement, whether the bottom line is we want to restrain the power of the federal government or we want to have free individuals. So Social Security. So an example of the shipwreck of progressive institutions, I don't know if Social Security counts. Today, 55% of the elderly get more than half of their income from Social Security. Those in the middle of the income distribution got 66% of their income from Social Security, 9% from private pensions, 5% from personal assets. There's something above 50% of elderly people were impoverished when the Social Security program was first enacted. They were dependent on the aid of their children. In 2009, the poverty rate among the elderly was 8.9%. That doesn't look like shipwreck to me. That looks like a program accomplishing exactly what it was intended to accomplish.
Let me answer this. First, the general point is that what happens is if you have a few defined and limited powers, the reading of the Commerce Clause that I would give, confining it largely to cross-border transactions, means that it doesn't overlap with establishing post roads with the patent system and so forth. So to give you but one illustration, under the Commerce Clause, can you escape the definite terms and limits with respect to patents and copyrights? The answer, I think, would be yes, but I think, and of course, the Copyright Clause would become useless, so we just cut it out artificially. And there's no question that if you're trying to figure out how these powers all sit together, the narrower reading that Chief Justice Marshall put together is going to be much more accurate than this one. On the question of whether Social Security is a shipwreck, you have to be very careful the way you evaluate it. The first thing is you cannot possibly try to figure out how the system looks or would have looked if you didn't have Social Security. The major accomplishment of Social Security was to wreck the private insurance pension plans that were starting to develop in the early 1930s because the federal benefits essentially co-opted everything that they had. If those things had been allowed to continue in orderly fashion, they would not have been funded by a system of cross-generational subsidies, and so they would have been as stable, for example, today as your Fidelity IRA is, because people would have their money in defined contribution plans, which would, in effect, make it possible to actually control the cost of the system. Second point you'd want to know is what's the rate of return. The original conceit of Social Security is we put everybody on today at age 65 or whatever it was, and that meant that people who put nothing into the system got lots out of it. So that if you check the amount of money that's coming out of the system and do it by years that people enter into it, if you got into it in 1935, you'd get 1,000% rate of return. By the time you get there, it's consistently down. Every one of you is going to be hugely negative with respect to the rate of return that you have because the program is about to go out of money at some point or another. Yes, there are fewer than 8% of the population, which in fact is in poverty if they're over 65, because they're huge recipients under both Social Security and under Medicare, and to some extent today with respect to long-term facilities, even under Medicaid. But the percentage of people who are in below the poverty level in the prime of their income years is, of course, far higher than 8% and continues to increase. And it seems to me to be very odd to say that what we do when we evaluate the soundness of an overall program is to look at those people who succeed under it without taking into account those people who fail under the program in question. As regards Medicare, the thing is essentially bankrupt as of 2018. What will happen is you will either have to ration benefits or exclude those people of more substantial means from getting anything back from the money that they put into the system. We have here an entitlement crisis, which is already experienced at the state level and will happen at the federal level. because they constantly think about redistribution and they never think about the productive forces that are needed to keep these entitlement programs going. So yes, I think we ought to be quite gloomy about these things. This was evident as far as I was concerned 40 years ago. The only question was whether it would take 40 years to do it, 50 years to do it, or 30 years to do it. And you know, the internet boom is over at this particular point, and so at this point, I don't think that you're going to find any clever way to reverse the situation.
Under your understanding of the Commerce Clause, is it permissible or desirable to force doctors, all doctors, not just hospitals, to give free or reduced cost care? Would that more directly solve the problem, and is that permissible?
Well, requiring any individual to render personal service to another individual is a violation of the 13th Amendment. That's been established for 100 years.
Is it?
I'm saying, could they do this under the Commerce Clause, even if it violates people's rights? But never mind the rights, could they do it? It's an odd sort of question. Can we, enforce, could we tell Filburn that if you grow wheat on your land, you'll be tortured to death? And never mind the 8th Amendment. It's just an odd question.
Could I clarify?
Please.
Maybe to make it more reasonable then.
It's perfectly reasonable.
If we assume, if we, fine, to get rid of the 13th Amendment issue, we say to be licensed as a doctor, you have to provide X number of, reduced hours of, reduced price hours of care and things like that. That seems perfectly within the structure, right?
Well, we've had, now I'm in agreement with Richard that wage and price controls don't make a whole lot of sense in themselves. But is it possible to say, that we're going to require specific work as a requirement of having a license in the same way that we require, pick an example out of the air, some states require lawyers to do pro bono work. Well, I'll tell you that some states require lawyers to do pro bono work.
Yeah,
So I'm trying to figure out what the question is. Suppose we hypothetically lived in the world we actually live in? I'm still losing the question.
No, can I answer the question? I think I understand it. Judge Lippman of the New York State Court of Appeals has now announced that any person who wishes to enter the practice of law in New York State must do 50 hours of pro bono work. And this was greeted with great adulation amongst the people who thought it would solve the problem, not realizing that many of these people who have to do the 50 hours of work may be in debt to their eyeballs from law school, and it might be the difference between success and failure. I take the earlier position on this issue. A licensing power is introduced for only limited purposes, mainly to make sure that there's a minimum level of competence of those people who fact within the field. And I think it's an impermissible form of leverage for the government to now use it as a transfer system. This was the view taken way back in 1905 in some of these earlier cases on the Good Samaritan rule, and I think it ought to apply categorically to doctors and to lawyers. The situation will not be stable because once you allow it for new guys, you can allow it for old guys and so forth. Indeed, here's another version which will wreck everything. If you decide to take Medicare patients on Medicare fees, you cannot take other people without taking Medicare fees and so forth. At present, every one of these conditions is regarded as illegitimate. I regard them as desperate efforts. What you're doing is you have a boat that's floating and you have something that's sinking, and you hope that if you tie the two things together, the boat will hold and nobody will sink. The real danger is that both will go under. And I don't think the Constitution of the United States allows the government to use its licensing power to force any redistribution of services amongst any individuals. If you wish to do that, there's a tax system. You tax and you pay in order to stop the problem of hitting very hard on isolated factions within the country. That is, the difference between targeted and general revenues is the difference between the dangers of and the relative stability of majoritarian politics. And so long as factions are an issue, then it seems to me that what you suggest ought to be regarded as flatly illegal. It is, of course, lost in every single case that it has been brought, and I attribute it to nothing more than the inexcusable myopia and political ignorance of the United States Supreme Court. I am on tape, aren't I? Thank you.
Professor Koppelman, I have a question for you.
No one has a question.
So Professor Epstein suggested that the collective action problem that has been caused here is caused by the federal government. in large part. Now, we can argue about
Or by
whether
state
this
governments.
one actually was created by the federal government, but let's say that the federal government did cause its own collective action problem. Would you still support this, the federal government being able to then legislate based on that problem they created?
Well, there are a couple of different levels of question. First of all, I'm not sure whether we're talking about constitutional law anymore. So if the proposal is that the Supreme Court should do its own economic analysis of the regulatory scheme, decide whether it's persuaded, which analysis of the regulatory scheme persuades it, and then invalidate the regulatory scheme if it thinks that it's counterproductive, that it's just, we're not talking law anymore, and that exceeds the institutional capacities of the Supreme Court. The question of, so if the question is, well, there was a suggestion in some of the district court opinions that Congress can't enhance its powers by trying to remedy a problem it itself has created. And it's certainly the case. I mean, Richard actually laid it out very nicely at the beginning of his talk. Once you have guaranteed issue, once you say you have to provide health insurance to anybody with pre-existing conditions, then there is an enormous adverse selection problem. People who are sick are going to buy into the system. People who are healthy are going to get out. And so the mandate is in response to that. But lots of federal laws create problems that require additional legislation in order to remedy. That's just an ordinary incident of federal power. So just go back to mail robbery. Whose fault is it that all of those valuable papers are collected in one place? It's only because the federal government chose to operate a post office, which it didn't have to. It's authorized to, but didn't have to. And then you get the problem of mail robbery, and now we're putting people in jail. So I'm not sure what the difference is in principle.
I think there's a huge difference in principle. In the one
I knew
case,
you would.
the government is trying to figure out how to run its own affairs, and like every business, it has to be given to some discretion. In the other case, it's trying to coerce other individuals, and in those circumstances, the burden is higher. But I want to point something out. I always regard institutional competence arguments as the last refuge of a Supreme Court scoundrel. And if you listen if you listen to this particular situation, the original Koppelman presentation was to explain in exquisite detail as to how a collective action problem could be wisely solved by the United States government through its prudent interventions. And what was that other than a clear analysis of what the sources of our difficulties were and what the proposed cures would be? Now, my view about it is that you have to be competent when you do your institutional competence analysis. I have spent, I can't say how many hours looking over this bill and years teaching in the healthcare system. I can't think of a more inept system of healthcare prevention that you could create than the one that the federal government has taken. And so just at the situation, you're talking about insurance. Now, you want to talk about social insurance, that's a transfer system. But there's nothing which says that when you want to do transfer systems, you have to be stupid about the way in which you do them. And so it is perfectly consistent with the system of social insurance to have a waiting period on the one hand or a minimum term of office that is taking the policy in order to make this thing go. Because you still guarantee access, but you now control opportunism. If these methods are available, and if they were told time after time about this problem, the question then is, why does it make the slightest bit of sense to start to go down this mandate road, where in effect, if you could do it for $700 in this particular program, how much could you do it and for what particular reason in other programs? Essentially what happens is the government will be allowed to say, we can engage in systems of systematic misrule, so long as we're allowed to hit some hapless individuals to make us pit up the difference. And my view about taxation is, I'm sure Andy agrees with this, is that the risk of faction is so great that I've always thought that the constitutional requirements for a flat tax, the argument for that was extremely strong. It is in fact the law with respect to First Amendment type issues under the Minnesota Star case. And I think it ought to be the rule here. Because otherwise this toxic combination of ad hoc regulation, differential tax rates, all sorts of exemptions, tying arrangements and so forth, will take this economy to put it into a knot. The original purpose of the Commerce Clause was to allow the federal government to create a common market in the United States. What we've now done is managed to make it look like the worst features of the European Union as it meddles in everybody's business, and with each successive intervention, it manages to do something more ridiculous than it did the previous time. This is meant to be bipartisan, as you understand. That is, I am not trying to defend Republican administrations for their deep loyalty to the principles of laissez-faire through the Sarbanes-Oxley Act or something of that nature. So I think, in effect, that we are now witnessing basically the decline of the United States because they don't understand the First Amendment, which is what you cannot produce, you cannot redistribute.
I'll say since the New Deal, from then until now, there are periodic statements about how the United States is in decline and the American economy is coming to an end. During that whole period, the United States continues to produce about 25% of the gross national product.
We understand, but look, it depends on what the systems are. The great problem is that the progressive movement has the same view towards redistribution that it did in the 30s. In the 30s, it took the government from 3 to 6% of the GDP. It's another thing to try to take it from, by direct payments, of 18 to 25% and so forth. There are marginal returns, and all of the political devices which during the Eisenhower years kept things relatively stable, the slight retardation of growth during the Reagan period, all of this stuff has been put to the winds. And the argument is not whether or not you can survive redistribution. If you had a penny's worth of redistribution in a $1 trillion economy, not a problem. But what happens is we've now lost the balance. And as we've lost the balance, we've become more and more desperate with respect to our entitlement programs and more reckless with respect to our production programs, and we have indeed gone over the edge. And as for the long-term situation, the United States in 1945, relative to the law, was so far more dominant than it is today. It has been a slower decline, more rapid after 1970 than before 1970, more rapid after 2000, to pick a Bush year, than it was before 2000. And given what we have at the state level with pensions and so forth, and budget shortages, and what we have with our $1 trillion deficits, which are no end, I think we're in very parlous state. We cannot make good on our IOUs, and the cruelest thing in the world you could do with people of limited means is to say, here you have an entitlement programs, but you have no money to fund it. The biggest system of entitlements in the world is found under the Soviet Constitution. We ought not try to emulate them in the way in which we conduct our own political affairs.
Please join me in thanking our speakers.
Good to see you.